Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. In the area of juvenile law, most of us are familiar with the county children and youth agencies and how they can file actions in court seeking that a minor child be declared a dependent of the state and thus removed from the custody of the child's parents. But did you know that any person, not just the county children and youth agency, may make that request? Any person may request court permission to file what is referred to as a petition for juvenile dependency. A recent Superior Court decision highlighted this little-known provision in juvenile law. The case is known as In Re TMA. In this case, the grandmother, or at least the woman who was considered by the child to be her grandmother, filed an application in court requesting permission to file a petition to have her 17-year-old granddaughter adjudicated a dependent. After an investigation, the trial court granted the grandmother's application. She then filed a petition in court averting her granddaughter was without proper parental care or control and requesting the court order that she be declared a dependent of the state. Now, for much of her life, the child had lived on and off with her mother and her grandmother. Mother and child had a strained relationship, and the mother had difficulty controlling and governing the child. At one point, the child was in shelter care due to a juvenile delinquency matter, but she had refused to return to the home of her mother. And in fact, she was still on juvenile probation at the time of this case. Because of the strife between the mother and the daughter, and perhaps because of the mother's neglect, the child was without health insurance coverage, had dental care needs that were not attended to, needed insurance or payment for her therapy and mental health care, and needed food, clothing, and shelter. The grandmother was not the child's legal guardian or custodian, and thus lacked the legal authority to, as the Superior Court described it, oversee all of the child's medical and educational needs, ensure that she has a consistent home, and address her care, treatment, and supervision in any sort of coordinated or comprehensive manner. Interestingly, the County Children and Youth Agency actually opposed the grandmother's petition, arguing that she stood in loco parentis to the child and she could obtain medical assistance for her. The trial court disagreed with the County Children and Youth Agency and ruled in favor of the grandmother, declaring the child to be a dependent of the state due to the parent-child conflict. More particularly, the trial court ruled the grandmother met her burden of proof, that the child had committed a specific act or acts of habitual disobedience of the reasonable and lawful commands of her parent, guardian, or other custodian, and who was ungovernable and found to be in need of care, treatment, or supervision. The County Children and Youth Agency actually appealed that trial court decision. It went up to the Pennsylvania Superior Court, which affirmed or kept in place, agreed with the trial court decision. Thus, the child has been adjudicated a dependent, and the grandmother named as the child's custodian by the court. This will give the grandmother the legal authority to provide the care that the child needs. So that's a little-known provision of the juvenile law that lets any person, upon applying and receiving permission to, file with the court a petition seeking that a child be declared a dependent. Well, that's all the time we have today for the Scaringi Law Lunch Break. I hope you learned a little bit about the law. Thanks for listening and enjoy your lunch.